Dear colleagues, ladies and gentlemen, thank you for inviting me to say a couple of words at this important event. Undeniably, these are very trying times. Obviously, the world is preoccupied with fighting the COVID-19 pandemic, and at the same time, there are serious concerns regarding the state of the rule of law in some countries. On top of that, terrorism remains a serious threat in the EU. It seems one goes hand in hand with the other, and all directly and indirectly affect cooperation in criminal matters within the EU and wider. Let me start with the rule of law. Of course, the EU is based on a set of shared values which include fundamental rights, democracy, and the rule of law. And this is the precondition of mutual trust. When issuing or executing orders like an investigation order or an arrest warrant, we have to trust and believe that the other jurisdiction respects human rights and has all mechanisms that guarantee the respect of the rule of law in place. If we do not trust the authorities of another member state, judicial cooperation cannot be efficient. For example, if we do not want to surrender one of our citizens to another jurisdiction, unless we are convinced his fundamental rights and freedoms will be fully respected. Promoting efficient and direct judicial cooperation with as few grounds for refusal is at the core of the idea of establishing the area of security, freedom, and justice. Otherwise, we would be left with more or less classic mutual legal assistance with all its downsides and inefficiencies. But where do we stand in the EU today? Obviously, there have been serious issues with the rule of law in some member states. Consequently, the European Court of Justice issued a couple of judgments by which the practitioners were given a challenging task of resolving the tension between mutual recognition and the protection of fundamental rights on a case-by-case basis. Concretely, in the context of European arrest warrant, the Court of Justice has acknowledged that the executing authority may, in exceptional circumstances, refuse to execute an EAW where there is a real risk that the surrender could lead to inhuman or degrading treatment owing to detention conditions in that state. Further, an EAW can be refused if surrender could lead to a violation of the fundamental right to a fair trial due to concerns about the independence of the judiciary in the issuing state. We're used to taking into consideration issues like these when we're dealing with classic mutual legal assistance. That is, of course, mostly with third countries. But how will practitioners tackle this issue at the European level now? The court in its judgments already pointed at using terms like inhuman and degrading treatment or right to a fair trial within the meaning of the EU Charter on Fundamental Rights. Further, there is a database set by the Fundamental Rights Agency, bringing together in one place all information on detention conditions in all member states. And of course, there is invaluable work of the Council of Europe and their instruments. As a consequence of all this, there are also debates on how to avoid impunity in a Europe without borders. Namely, if the execution of an EAW is refused, the question arises of how the proceedings can be transferred effectively and how conflicts of jurisdiction can be resolved. There are extensive discussions within the Council at the moment on this subject. So it seems one of the biggest challenges in the area of justice is the rule of law. It is very important that we establish that this concept is tangible. Undoubtedly, the rule of law is a very established principle. And while member states have different legal identities, systems, and traditions, the core meaning of the rule of law is and should be the same across the EU. The rule of law includes principles such as legality, separation of powers, right to judicial review, effective judicial protection by independent and impartial courts. So, judiciary is at the heart of the rule of law debates in Europe. This is understandable given the challenges in some countries relating to judicial independence. As the rule of law can be jeopardized when efficiency and independence of judiciary is hindered, it is thus important that we have national as well as EU mechanisms in place in cases of backsliding. Therefore, I firmly believe that objective mechanisms, like the European Commission report on the rule of law, are very important. This report provides a clear overall picture based on the same criteria for all member states. Moving on, one of the further areas that are being addressed at the moment within the Council in the field of criminal matters is digitalisation, exchange of e-evidence and tackling hate speech online. In recent years, a lot of serious criminal activity, including terrorist, had moved online. And we need to ensure more efficient mechanisms for cross-border access to e-evidence. I'm sure Angers will tell you more about this, since the proposal is currently awaiting the adoption of European Parliament's final position. On one hand, law enforcement authorities are confronted on a daily basis with difficulties in accessing electronic evidence in serious crimes investigation, including terrorism. However, it needs to be done in a way that respects human rights and freedoms. And this, of course, is no easy task. The recent terrorist attacks in Europe have also shown that criminal hate speech will have to be regulated at the European level. Incitement of violence, dissemination of anti-Semitic, racistic, and other discriminatory propaganda, like hatred relating to gender, political affiliation, or sexual orientation through social media platforms, increasingly plays a harmful role. Of course, as Europeans, we value freedom of expression. However, internet cannot be a safe haven for criminal speech. What is criminal offline should be criminal online. Internet companies hosting such content must take responsibility for the misuse of their platforms and should cooperate fully with law enforcement authorities. Let me conclude on a personal note. It saddens me gravely that we need to address issues like right to a fair trial in the context of judicial cooperation at the EU level in the 21st century. I started working in the field of justice in 2007, just before Slovenian first EU presidency, and those were times of great optimism. The area of criminal justice was one of the fastest developing areas at the EU level. We were very much focused on human rights and procedural safeguards. Now, as we're preparing our second presidency, the mood is quite different. Sadly, different issues and challenges have emerged, and I cannot avoid feeling that in the area of justice, we're just trying to treat symptoms of a problem that has been generated in other areas, like financial markets and the economy. Now, all this seems to be even accelerated by the COVID crisis. Personally, I'm not convinced that more repression will solve any of those issues, and hopefully we will regain our focus. So, dear colleagues, I wish you a successful conference and stay safe.